SJC-12336, Commonwealth versus Silva.
Mr. Baylor, good morning.
Good morning. May it please the court, Jeffrey Baylor for Joshua Silva. First off, we contend here that an error occurred when the trial judge gave a magnifying glass to the jury, and that this created harmful extraneous matter for the jury's consideration. What happened was, during deliberations, the jury sent the judge a note asking for a magnifying glass. Initially, the judge said, we don't have a magnifying, well, he didn't answer the jury, but in talking to counsel, he said, we don't have a magnifying glass, and there was no evidence about a magnifying glass at trial, and the judge didn't believe that he could just give a magnifying glass to the jury. But he said he would think about it overnight and have some research done on the issue. The next day, he came back and said that he believed that it was his discretion whether or not to give the magnifying glass to the jury. And over objection, he did give the magnifying glass to the jury.
Did he give them any instructions on how to use it?
No.
No?
I think there was just general instructions, but nothing about how it should be handled. I'm sure my sister will remember the exact words, but there was nothing specific saying you can do this or that. We have no idea actually what the jury used it for or wanted to use it for. The judge put on the record that he believed it was to look at pictures, still pictures and videotapes of pants worn by the defendant. The judge said that the color on the pants was powerfully argued by the defendant, and he thought that the jury would probably want to compare stains on the pants. What happened was...
And did he, well, in the closing argument, I mean, the argument, did the defense attorney also argue that there was a discrepancy between those two?
Yes. What happened was that there was videotapes and still pictures introduced at trial. The first videotape supposedly showed the defendant driving to the decedent's house and then driving away. And then later that day, the defendant was seen walking behind this restaurant called the Pasta House.
You know, wouldn't it be more problematic if Judge Kane had said, here's your magnifying glass, and when you're looking at the stills from the Pasta House at the defendant's pants, you can ask whether Mr. Belzos was right about it. So if the judge had given them instructions and guided them as to how the magnifying glass were to be used, wouldn't that intrude upon the province of the jury? As opposed to, they asked for a magnifying glass, there's an issue raised by a very good defense attorney about the still photograph, my discretion, and he hands them the magnifying glass.
Well, it comes down to whether the magnifying glass created an extraneous matter.
Right,
for the
and I
jury.
guess the issue that the case law discusses is whether or not that's an extraneous matter when the jury is using it to amplify that which is in evidence.
I'm sorry.
The jury is using the magnifying glass
Yes.
to amplify what is already an exhibit.
Right, and we
If you
can,
took my Coke bottle glasses,
Yes,
right, and
yes.
you manipulate them, that could be a magnifying glass, right? So,
Well-
extraneous means something outside of the evidence. This is the evidence, right?
well, there is one case cited by the Commonwealth from federal jurisdiction that says it's not extraneous because of magnifying glasses like glasses. But we contend that glasses would just show normal vision. So at trial, the counsel would know these jurors are going to be looking at these items with normal vision.
So I've got my iPad here, and I take your exhibit,
And I can make it bigger.
Yes.
So am I exposing myself to extraneous influence because I can expand my picture with
Yeah,
my
I mean, and that's
iPad?
something I've thought of. And yes, I think it is, because it's extraneous, because it's not something that was presented at trial. The defense had no opportunity to
Now, even though I don't see that well, and one of the reasons I do that is I can actually see it. So
Well, I would
that-
say that it's beyond normal vision. And part of the problem here is, as the judge quoted this law review article from Ms. Witkowski, the pictures at least were digital images, and that digital images are very different than what we think of in terms of photographs. The digital image only uses a very small portion of the color and the image and sort of extrapolates as to what would be there. So trial counsel is seeing what the jury is seeing from these pictures and videos, but no one is seeing what the jury is looking at when they've expanded. I mean, it's as if they had asked the judge for enlargements of the pictures. We don't know what the jury is looking at, and we don't know the effect.
Well, excuse me, when the jury asked for the magnifying glass, did they say what they wanted to do with it?
No.
So it might have been because somebody had a splinter.
It could have been anything. That's part of the big problem. That under Fiddler, we just have to show by a preponderance of the evidence that there was extraneous influence, and then the burden goes to the Commonwealth to show that it wasn't harmless. So, I mean, the trial judge seemed to think it was pictures and video, but it really could have been anything that they were looking at. But I guess you can infer that they're looking at these pictures, and as I say,
Pictures were of what?
well, that's, as I was saying, there was a video taken behind the pasta house, which was purportedly shortly after the incident. And the client's pants are shown, he's wearing tan pants. A couple days later, police recovered the tan pants, and at that point, there was a clear staining and blood on the pants, and DNA was found, the decedent's DNA was found. But in the meantime, these pants were thrown away in a garbage can and brought to police by a Mr. Chacon. So one of the arguments the defense counsel made was, look at these pictures from behind the pasta house. There's no staining on the pants, or we can't see staining. Maybe there was a little staining.
And who made that argument?
The defense counsel.
That's-
And then he said, but look at this, 2 days later, when these pants are recovered, they're totally different. They're totally dirty. And pictures of the pants as recovered by the police were given to the jury, and the videotape was played for the jury from the pasta house, and also from Cumberland Farms that same day showing the pants. And stills from the pasta house video was given to the jury. So the trial judge thought, oh, the magnifying glass must be because the jury wants to compare, look closely at these. And we don't know if they looked at the video. We don't know if they looked at the stills. But we do know that it was all, it was not a regular 35 millimeter camera. It was, digital images, which opens up a whole other issue as to the effect of a magnifying glass on enlarging an image.
But where do we, I mean, I know you characterize it as extraneous. Has any court characterized magnification of sight or sound as extraneous?
Not that I could find. I mean, there are some very few cases dealing with magnifying glasses. There's a very old one from Massachusetts from the 1920s cited by my sister. In that case, the magnifying glass was used at trial, and then it was a question, well, does the judge have discretion to give the jury the magnifying glass if it was used at trial? So usually, it looks like the magnifying glass comes up because it was used at trial, and then should the jury have it or not? Not that it was totally not used at trial, and the jury just asked, I mean, it doesn't seem like, at least from my looking at the cases, that it comes up. It's hardly come up at all.
And does the record reflect how magnified it was? Was it 5 to 1, 8 to 1, 10 to 1?
I don't believe it did, but the magnifying glass was, well, a photo of the magnifying glass was marked for identification. I believe they borrowed it from the Registry of Deeds.
This was to help people who
It
otherwise would
wasn't
have
it an
trouble reading.
official Registry of Deeds calibrated or something? I mean, what would they do to it?
There was nothing, I didn't see anything on the record about that. I mean, at the Registry of Deeds, I imagine they
So it was
just,
just there,
Yeah,
what
the-
was hanging around?
yes,
Okay.
yes.
So
Got it.
where do we go with this? If we give a tape recorder to the jury and the jury decides to turn the tape recorder up high so as they can listen better to the sound, is that improper because they're magnifying the sound?
Well, that's an interesting question, and I would say yes, because the defendant has to have a chance to, argue about whatever the evidence is, and also to present witnesses about it. And here,
We instruct the jury to keep it at conversational volumes.
I would say, I would say nothing that wasn't presented at trial should be, should be considered by the jury without giving, both sides a chance to introduce witnesses, to argue about it. I mean, this is a case where the jury is making their own evidence, and that is even if they were looking at the photographs and video.
Now, aren't there some federal cases that hold that this is all right? It's just a way that even if you don't know what the jury's going to look at it for, it's just a better way to look at
Yeah.
exhibits?
There's one case, I think it's Brewer. It's cited in the Commonwealth's brief, where the court said it's just like glasses.
Do you think this is a matter of judge's discretion?
Well, I think, in that 20s case, they said it was a matter of the judge's discretion, but that was when the magnifying glass was already introduced, or used during the trial.
We should say as a matter of law, this was prohibited.
Yes, because it's just like any other extraneous matter going to the jury.
I guess the chicken and egg issue is whether it's extraneous, right?
Right. So, regardless of whether it's discretionary, it comes down to whether it's extraneous. If it is, then it shifts to the Commonwealth to show that it was harmless beyond a reasonable doubt. And without knowing, especially without knowing what the jury used it for, there can't be a showing that it's harmless beyond a reasonable doubt.
But you have, there was no motion for a new trial here, correct?
Correct.
So we don't have any testimony from Dr. Witkowski saying that this actually could have resulted in a distortion of what is a fair and accurate reflection in the digital.
Right. But when we look at the burden, it would be the Commonwealth to say that it didn't, not that
That all,
for us to say
that
that
all
it did.
rests on your characterization of it as extraneous.
Right.
If it's not extraneous, then the burden would be on you to show that it affirmatively resulted in a distortion of the evidence which was prejudicial to your client.
Right. And at this stage, the trial judge looked at it and thought, he had discretion to give them the magnifying glass. So that's where it is at this point, are saying that he couldn't, because he can't give the jury an extraneous thing.
Okay, so pragmatically, if we don't agree with you that it's extraneous, do we then have to go buy a magnifying glass and look at the photographs and see whether we agree there's any distortion? I assume you say we shouldn't do that.
No, because it would be for the Commonwealth to show that it wouldn't have an effect.
And as we move increasingly to digital trials, where the jury would arguably be given something in the jury room that would allow them to see the digital evidence, we have to deal with the Justice Kafka problem, you would say. We now can tell them they can't play with the iPad or whatever we give them to look at digital evidence. They can't enlarge it, they can't increase the sound? They just have to see it as it
Yeah,
is?
I would say yes.
Would we ever be able to have a blind juror or a deaf juror
I mean, to hear,
and see things without assistance of some sort that might become extraneous?
so the deaf juror would have something that enhances the sound, is that what you're saying? Well, I would say as long as it's enhanced to like a normal level that a full hearing person could hear, that's not a problem.
What about a translator?
The same thing. I mean, a translator for someone who doesn't speak English is just making it,
And I meant for a deaf person
oh,
also.
I'm sorry.
That's okay.
For a deaf person,
Sign language.
as long as they're not changing or enhancing what was done, I think that that's absolutely fine. The problem here is that it's been enhanced, and we have no idea what they were enhancing or what the effect of the enhancement was.
I mean, the enhancement's an interesting issue because, as you know, on digital evidence, there are experts out there that enhance or try to enhance
Right.
evidence through computer programs and take out noise and audio, et cetera. But isn't that a different animal than manipulating the iPad to make something bigger or staring at it unnaturally close or using a magnifying glass?
I don't think it's
Because I think an enhancement might be extraneous. You're probably right. A computerized enhancement would probably be extraneous.
yeah, well, I guess my first thought is when something's enhanced, then there's witnesses that can be called to say, this is what we did, and this is the
This is the
effect.
computer program, and this is legitimate, not legitimate.
Yes.
And it can be tested.
So if someone in the jury had an iPad and was expanding it, I would say that without any testimony or anything at trial, I would say that that's exactly the same as giving them a magnifying glass. Because we have no idea, you know, how, well, at least I don't know how an iPad really works when it expands. Does it take like one single, it seems from this Wachowski article, it seems like there might be some sort of dot of color, and once it expands, the digital image might
No, I
make
think
it seem very large.
The experience of anybody looking at digital photographs is that they pixelate and they
Right.
become unusable at certain points, unlike old traditional photographs.
Right. So so I guess that if we go into the iPad example, that's even worse than, well, it's equally as bad as using a magnifying glass because
Do we have, by the way, the picture here? Did you give us the picture?
I gave you the pictures in black and white.
Where is it?
It's in the appendix.
Just looking for it, I couldn't find it.
There was color pictures in the court, but unfortunately, they didn't have a color copy.
Oh, so you photographed
I
them? Oh, you Xeroxed
yes,
them.
I wrote in my note that these are black and white copies of
What
color
page is it on
images.
in the appendix?
It starts at 19, which are the pants as they were found by the police.
So your record appendix?
Yes.
Oh, I see.
And then there's the stills from the Pasta House video, which is start on 24.
Problem is, when you give us black and white.
I know.
Kind of hard to do this. But I can blow them up. I can make
Well, you can see, it changes it, doesn't it?
No, it doesn't,
okay.
because I can't see almost
Okay.
anything. You
Yes.
can't tell any color on what you've given us.
Yes.
no
Because
matter what.
I thought that these were at least adequate to show what the pictures were, because we can't know what the effect on of the magnifying glass was when the jury looked at it. So even if you had like crystal clear pictures,
But the magnifying glass is at Appendix 29. This is not exactly
Page 20.
something that's going to allow you to see atoms.
well,
I mean, this is what
true,
you,
but
what you use if you've got an Oxford English dictionary and you need to help enlarge
true,
the
but
print.
right, it wasn't a microscope, so we don't know what the effect of this would have had. Again,
I'm looking at a
it's
pellet
just something
silver.
that we don't know.
And again, we don't know what they were looking at.
We don't even, just the judge said he thinks he used it to compare. And we don't know, does it have one effect on looking at a video? Does it have one effect at looking at a photograph?
And it is in evidence, isn't it?
The magnifying glass?
That's the
I
still.
think it was just, if I remember, the magnifying glass was returned to
It
the
was
registry
returned.
and they just took they took a photograph of it.
Okay.
Yeah, it's just marked for ID.
I see.
83?
83.
Yeah, so it's
So-
still
so it
photographs
was
at page 83 that you're talking about.
Still photographs are, I'm sorry,
Well, the 24 and 25 of your record appendix.
yes,
26 are
And
the still,
27.
are the still photographs
from the Pasta House
from the pasta house.
video.
Right, which presumably would be compared against, were actually the pants introduced into evidence as well, or just photographs?
Yes. And,
Physically, they were introduced into the evidence as
yes,
well, right?
and the videos were played for the jury too, from Pasta House and Cumberland Farms, which also showed the pants.
And was the video black and white or was the video color?
I would say color, but I really just, I don't want to misrepresent anything. I think that the photos were in color, so the videos must have been in color.
Where are the videos?
What's that?
Page 25 of the,
Page 25,
of the appendix.
which is
Page, like, 183,
183.
86, I'm sorry, Justice Link, 86 of it.
That's the exhibit number? The
No,
videos
this
are
is- I see the dirty
page
pants, I see
24,
that.
25.
If you go on, you'll find the
23,
videos.
24, and
Like a
25.
ledge.
For the record, we're all using our iPads.
You know. But you're not enhancing them, you're just.
I
looking
Yes,
at
yes, we are.
No, we're all enhancing them over.
I'll plead guilty
That's
to
within the
enhancing.
realm of, okay,
Okay.
your time is up.
Okay.
Thank you.
Thank you.
Ms. Johnston.
May it please the court, Tara Johnston for the Commonwealth. So the first issue I will address is, of course, the magnifying glass. So one thing I want to make clear is that the judge in this case, in exercising his discretion, he looked at these exhibits that he believed to be the issue, that for the reason why the jury was requesting the magnifying glass. There's surveillance footage from the Cumberland Farms, surveillance footage from the Pasta House, and also the stills. And he made the determination, being very aware of the issues with digital versus 35 millimeter camera and how digital, the issues with that. He cautioned about that, and after cautioning about that, considering that,
Did he look at them with a magnifying
he
glass?
did. He used the Registry of Deeds magnifying glass that he gave to the jury, and he concluded doing so. After doing so, he concluded and he explained to the parties, I've done this, and all it does is give a better view. That's all it does. Because of that, I am going to accommodate the jury's request for the magnifying glass.
What was the instruction he gave the jury?
He gave an instruction making it clear that any exhibit, including any digital or photographic exhibit, you have to take into consideration that it's not necessarily an accurate depiction. So he said, and now I'm going to accommodate your request for the magnifying glass, but he gave that instruction that anything has to be looked at in its entirety, taken into consideration with all of the evidence you've heard about it, and that it's not necessarily an accurate depiction. So he did give that cautionary instruction. Also,
But the jury was never informed about this law review article or this expert testimony saying that digital takes the color from, doesn't show the actual color, but takes the majority, whatever, of the pixels and.
no, they were not. They were not informed of that. They were simply informed of that it may not be an accurate depiction, which I would say is sufficient in this case, especially where you have a judge exercising his discretion, being very careful of it, being mindful of the issues that are of concern, and checking it out with the magnifying glass himself to make sure that it doesn't create any problems, it doesn't distort the images, and it does maintain the integrity of the evidence, which is exactly what he determined in this case, that it did maintain the integrity of the evidence by finding that it just simply gave a better view and accommodating the jury's request. Also, I want to make clear that in my brief, I simply cite a Ninth Circuit case, United States versus Brewer, in which the court found that it's no different than using corrective lenses. There's a Seventh Circuit case, which my brother cites, and which I also cite, United States versus Young, where they say there might be some case out there in which it might be constraneous can be considered extraneous matter. They don't give any type of example, but they find in that case it isn't. There are other cases.
What was the use in that case?
In that case, I believe it was for photograph exhibits. In one of the cases, United States is Brewer or United States Young, it was.
Do you agree that it would have been problematic for Judge Kane to have said, now, when you're looking at the Pasta House video still?
Yes, I don't think that would have been appropriate. I think that he gave an appropriate instruction, just explaining that it's just that the images themselves may not be accurate, to keep that in mind when looking at it. Of course, the jury understand the purpose of magnifying glass is to magnify images. There are also other cases. I don't have them cited in my brief, but I have researched it, of course, just to determine what other circuits have found, and other circuits addressing it. There have only been a couple, but in addition to the 9th Circuit and the 7th Circuit, the 10th Circuit has addressed it, 4th Circuit has addressed it. They've also found, again, matter of discretion for the trial judge. As state cases that I've looked at, I've not found one case where the court has ever found that it's an abuse of discretion or improper for the jury to accommodate a jury's request for a magnifying glass, or that it's considered extraneous matter in any way. This is a tool to look at the evidence
So
before
I guess,
them.
could there be, I mean, you got a picture of sort of a grainy picture, and that's what the jury saw. They asked for a magnifying glass. You get the magnifying glass, and it shows he's got a tattoo, and they've been seeing that tattoo in court all week. I take it that could be was that an extraneous influence? The jury, the picture they were all seeing, they can't see the tattoo, but with the magnifying glass, suddenly, eureka, we have the tattoo.
I would say that I would say possibly. I would say if it doesn't maintain the integrity of the evidence, I would say that that is why it is a discretionary call.
The thing is exactly what it was that the jury saw, but now with the magnifying glass, we got something that no one saw without it.
I would say that, again, as long as it doesn't distort the images. I don't think magnifying something I don't consider magnifying something extraneous matter, because then you could say somebody with different visions. Everybody in that jury room is going to have different visions. Somebody could have 20/20 vision. Someone could barely have not have good eyesight at all, and not have any glasses, and not have any contact lenses on. So you can't start, I think when you start doing that, you start creating issues of, is everything going to be seen the same way by every juror? Not necessarily, but as long as you're not distorting the exhibits that are before the jury, I don't think it's problematic or extraneous matter.
If a juror took a photograph of a photograph on his or her iPhone, and then used the whatever Photoshop stuff to enhance it, would that be a problem?
I think yes, I think that would probably be a problem. I think that
Because they've changed the medium, right?
yes, I think they have done so. I think they have done so, and I think jurors are specifically instructed also not to do that type of thing in the jury room. So I think that if you're using some kind of outside.
Well, I don't know if they are. Maybe they have to be, but I don't think they are.
Maybe, perhaps nowadays they should be, but regardless, I think that also in that situation, you're not having a judge make a discretionary call about the Photoshop, the app that's being used. So you're not having a judge look at that and saying, oh, I'm aware of this, I'm aware of the issues here, does it or does it not distort the issue? I don't think any court case that I found has said it goes to the jury no matter what, or the judge is required to accommodate that request. Absolutely not. That's why it's a discretionary call. And here, this judge was very careful in exercising his discretion. He was very aware of the issues, concerned about them, and made sure to be very careful and also to give a cautionary instruction. So
is the standard the risk of distortion?
I think it's abuse of discretion, and
But in terms of evaluating whether there is an abuse of discretion, is that what we would use to consider?
I think that would be the case. I think, yes, I think whether or not the judge properly exercised discretion in finding that it maintained the integrity of the evidence. And I think here we can find that that was the case. That he properly exercised that discretion.
And we don't know, we see the magnifying glass exhibit BB for identification, but we don't know what.
We do
degree of
not. There was nothing in the record as to the level of magnification of that magnifying glass. What we can see from the picture of the magnifying glass is it appears to be a basic magnifying glass. It's used by the Registry of Deeds. That's what we know. Yes. So I would say that
When you say distortion, because obviously a magnifying glass distorts the image in the sense that it enhances it. So it's.
I don't think.
So the standard for you is maintaining the integrity. I'm trying to understand what that means too.
Yes, we're trying to get the difference between this and my hypothetical on an enhancement using a computer program.
I think it depends on the enhancement. I think if it's just something that magnifies something, I think that it's a proper discretionary call for the judge to say it is just magnifying what can already be seen. It just gives a better view of it.
That can't, at some point that goes too far, right? If you have an some kind of fancy microscope and you're looking at things, you're going to see all kinds of stuff that's totally different, right? That's what scientists do. So at a certain point, it changes what the changes the trial evidence, right? I'm trying to, the question, I don't get how we're going to articulate the standard, because it magnifies, it distorts, but I guess it's when it transforms it into something.
We could just say all tools before the year 1990 are okay.
If it was used in Dickens' time.
Right.
It's okay.
I think when it's something like a tool like that, I think there's lots of matters such as this where it is really a question of the trial judge's discretion, and as long as I think that judges often have to make discretionary calls, and I think that this really is what it comes down to, is whether or not the tool being used somehow distorts or is capable of distorting the images. I don't see how this is any different from if somebody had super great eyesight in the jury room. Yes, this is magnifying something. It's a tool being used to magnify the evidence. But again, I think it's a question of discretion for the judge.
And leaving it to the judge's discretion would permit the judge to have the flexibility in any
Yes.
circumstance, depending on what kind of evidence, what kind
And I
of
think
tool.
that's absolutely necessary. I think that's absolutely
Judge
necessary.
needs a standard, though. I mean, that's what we're supposed to do, right? Tell them, okay, it's within your discretion to do this unless the evidence. He says provides extraneous, it makes it extraneous.
Well, he also gives he's also concerned about some type of distortion. He's also definitely concerned about whether or not it changes the evidence. He actually looks at it to make sure that it does not do that. So he has that concern, and he's making sure that that is not the case.
The judge had done that to see whether or not it makes it a materially different exhibit.
He did. He did that with respect to the surveillance footage and with respect to the stills.
Is that the right standard, just what Justice Gaziano said? It materially changes or transforms the image or makes it materially different. Is that the standard?
I think that would be a good standard, yes, if whether it materially changes it.
Well, every magnification changes it by magnifying it.
I don't think it materially changes it. I think there's a difference. I think there's materially or changing something. I don't think all all you're doing really is saying that you can see it better, you can see a closer look of it. I don't see that changing it. I don't see that actually fundamentally changing the evidence before the jury. The evidence that is before the jury is before the jury. Those digital images are before the jury.
I mean, I gather the Witkowski article, by the way, was that furnished by defense counsel to Judge Kane, or did he do this on his own?
No, that was not.
So
Yes.
we have a judge smarter than all of us who actually has thought of this.
Yes,
Has conducted his own research.
he did his
has
own research.
found an article which addresses the risk of distortion.
Overnight,
He did.
by the way.
Yes, he also purchased his own magnifying glass
Sherlock
to
Holmes
check this
himself.
out. And after purchasing his own magnifying glass, he got a better magnifying glass, or easier to maneuver.
So he
from the
certainly
registry.
was, and this article, I gather, says that under some levels of magnification, there can be distortion of color.
Yes, that the pixelation, it can make up for the in digital images. So a digital image will not be as good as, say, a photograph from a 35 millimeter camera, because you're making up some of the colors in the digital image.
So this article actually speaks of the risk of distortion.
It does, and he was
And
aware
is
of
that
that.
part of the
yes.
record, or do we have to do what Judge Kane did and find it ourselves?
I think you have to find it yourself. No, it's not part of the record. He cited it. He discussed it he cited it in the transcript.
Okay.
So also, I just want to make note, and I make note of this in my brief, that a lot of this issue, I just want to draw attention to the fact.
A lot of evidence here.
Well, yes, there's a lot of evidence. Yes, this is a case where the evidence against the defendant can be said to be nothing short of overwhelming.
We
But
don't need
also,
Sherlock Holmes to figure out a lot of this evidence, right?
But no, exactly. No, we do not. But also, I want to draw attention to the fact that it was the defendant in this case who made this big argument in the closing argument. Is a huge part of his case definitely a big part of his case, that I want you to look really closely at those videos. You can't see that blood stain in those videos. You see it on those tan pants you have as an exhibit. You can't see it on those videos. And here we have the judge instructing the jury, well, not everything's an accurate depiction. Take every piece of evidence as in light of everything. We have the Commonwealth even discussing in the closing argument, you can't draw that much, there's only so much you can necessarily draw from those videos or from those stills. Take it in context of the entire evidence. So it's really defense here who's asking the jury, look, I want you to look really closely. You don't see it. And then it's this idea of, but don't get a magnifying glass and look too closely. It's just somehow a little, it seems a little kind of almost disingenuous to be making the argument when it's really the defense at trial who's making this argument that these digital photos and this surveillance footage carry so much weight, when in fact the judge is instructing to take it for what it really is worth, and so is the Commonwealth. And I think the jury would have certainly understood the use of a magnifying glass. Also, as this court has noted, the case against the defendant, even aside from this evidence, was quite overwhelming. In addition to the bloodstained pants, the defendant made statements about returning to the victim's house to kill her, which I also want to touch on quickly, a couple of the other issues, just very quickly. One, with respect to the instruction, the circumstantial evidence, inference, the example, use the arson example. I just want to make clear that in the, and I don't think I put this in my brief, so I want to make clear that in the beginning of the trial, when he's discussing the instructions, the defense makes clear he wants a very clear instruction on circumstantial evidence and inferences, because it's a big part of the case. And the judge says, okay, I'm going to give the arson example. I think you're both familiar with it. The arson example I normally give, I've said it out for you. Nobody has an objection to that. So that's before he gives the opening instruction. He repeats that same instruction at the final instruction, but nobody has an issue with it. Defense knows of that instruction. It's clearly satisfying his concern that the jury is aware of circumstantial evidence and inferences. And he properly doesn't have a concern about it, because there is no issue with it. It's not given as part of the reasonable doubt instruction. It's entirely proper instruction. instruction, and the defendant's reliance on Commonwealth versus Permelo doesn't stand as set forth in the Commonwealth's brief because it just isn't given as part of the reasonable doubt instruction. So also, last issue, the statements that Diaz, the testimony that Diaz gave about the defendant's statements regarding the family next door and killing them.
Why did you introduce that? You seem like you took a really strong case and kind of put some evidence in there that you really didn't need that was kind of prejudicial.
Well,
I'm sure you would tell your trial lawyers not to do that.
I don't think so. I think that I think in this case it properly came in because it was a
I
statement.
know you're
of-
going to argue that, but
Even the baby?
I just don't know why the prosecutor
So
did
if you're
that when
saying
the
was the
evidence.
case, if the case was overwhelming even without that statement, I will say yes. The case
No,
against
but
the
I'm
defendant.
just saying to use your
but even
to tell them to use their head. Well, why would you try to do that?
Because I think it's important. I think it was an important part of evidence, and this is why I think it was important. One, it's a statement of an opposing party, but regardless of that, it shows the defendant's intent. It shows his state of mind. It shows his motive the morning before the killing. This killing only happens a few hours after that statement is made. What does that statement show? Well, it shows.
I'm not saying it's not admissible. I'm saying there's a balancing test of prejudice versus probative.
Certainly.
When we look at that,
I'd say
you
in
may want to
this
consider
case,
what type of evidence you have before you put prejudicial evidence in.
And did they put in the back part, like, because Diaz highlights, you're going to even kill the kid, right? You're even going to kill the baby,
well, so I
right?
think at that point,
Did they let in the whole exchange? I can't remember.
they let in the exchange. What happens is then after the reply by Diaz, "Are you even going to kill the kid?" Judge Kane says, "Okay, that's enough. I'm gonna tell the court, and tells the jurors, don't consider. You're not considering it for what Diaz said unless it gives any value, gives any intent, sheds any intent on the words of the defendant. Otherwise, you don't consider what Diaz said. So the judge did say that.
Say that, what the instruction is to the
So
jury
first,
is what?
he gives the instruction before the evidence, before the exchange is admitted. The judge tells this to the jury, okay, this evidence is coming in surely for the purpose of the defendant's intent. If you don't believe he said it, don't consider it. If you do believe he said it, give only its worth is only for any intent, light it sheds on the intent of the defendant.
And what is Diaz's statement about even killing the baby?
Then Diaz, so the defendant says, I would kill the whole family, I would rob the whole family, kill the whole family, including the kid. And Diaz says something to the effect of,
But
why
the
would you?
defendant says that? Or what is
The defendant says that.
defendant says what exactly? The precision of that may be useful. What does the defendant say?
The family comes outside with their little kid, and he said, if I robbed that family, I would have to kill the family, including the little kid.
He says that, including the little kid.
Yeah, he does say that. He says that. And then Diaz says, little kid, why would you have to kill the little kid? He couldn't something effective, he couldn't identify you. And then Judge Kane stops it at that point and says, okay, enough. And then you consider it, don't consider, we're not considering this man's statements, just the statements the defendant made. This man's statements, you only consider on to the extent that they may shed any light on what the defendant said.
But when he says this man's statement,
talking about
that
Diaz,
question that Diaz said, why would you have to kill the kid?
Exactly, yes.
But what about right before that, though, just the admission of the whole statement itself?
I would say that is, so certainly there, I don't think there's any question that it was properly admitted, and I think the Commonwealth did the right thing by admitting it because I think it sheds a lot of relevance on intent and motive about robbing the family and killing them. I think that the issue of the little kid, I think it all comes in because it shows the defendant's intent that day. He wants to kill. He doesn't want to leave a trace. He's intent on robbing somebody, getting that money for drugs. The motive in this case, the Commonwealth's theory, and he's going to kill everybody around, whoever it involves. Doesn't matter if it's a little old lady. Doesn't matter if it's a little kid. Doesn't matter who it is. He just wants no trace of it. He's intent on robbing a house and killing whoever's there. But even if this court were to say, okay, that portion about the little kid, that's a a little too, that was overly prejudicial, even if you take that out. In light of everything else, in light of given the statement, the part of the statement that was admissible, which is the remainder of it, that little portion of it, certainly, if they actually believed he said it, and it could not have prejudiced the defendant given in light of that piece of part of the evidence and all of the other evidence. But the Commonwealth, it does argue that that was, in fact, all admissible because it does show his intent, his motive, and his mindset that day. It shows that, and also I don't think this could properly be characterized as prior bad act evidence. It is just a statement. But regardless, even whichever way in fact you do, I think the value of that statement, that his state of mind that day, it only happens a few hours before the incident. And here he is saying, I'm going to rob and kill another family. What does it also show? It's just like it's just like the evidence of the statement he made a couple of, or an hour before that to a supervisor. That Friday he had gotten paid, but that Monday he's asking Amaral for money again. He's asking for $20. So it's the same reason that statement is admissible. That Monday morning he still wants money. He still is looking to do whatever he can to get it, and he's still intent on killing somebody if it means getting that money for drugs.
All right, thank you.
Thank you.
And we'll take our morning break.